Hello, everyone, and welcome to the Children's Commission's presentation on reevaluating reasonable efforts. We have made this presentation in light of changes that were made regarding reasonable efforts in the 88th legislative session. And we wanted to put those in context of the federal law that's long governed reasonable efforts to explain how those two fit together, the ways they're different, and the purpose behind both of those. The way this presentation will be structured is I will give a black letter law presentation regarding the Texas and federal law regarding reasonable efforts. Then we'll have a reasonable efforts demonstration based on a fictional fact scenario where we'll conduct a simulated hearing regarding a reasonable efforts finding. And then lastly, we'll have a portion of the presentation devoted to question and answer so we can answer your questions about how reasonable efforts work in Texas. So again, my name is Dylan Moench, and I am the Children's Commission Legal Representation Director, and Judge Piper McCraw is our jurist in residence, and she will be conducting our simulated virtual reasonable efforts hearing in the second half of the program. So the first thing I wanted to begin with is to discuss why reasonable efforts matter. Why are they important in the first place? And the reason why reasonable efforts are important is for several reasons, but one of the ones I think is often forgotten is to encourage the development of services to protect children in their own homes so that they don't need to ever be investigated by DFPS in the first place. So it's to build in the community services and resources that are available so that children are safe and don't need to ever have contact with the system in the first place. And then the second is that if children do have contact with the system, that they are only removed from their families if it's absolutely necessary. And I think the recognition there is that the harm that comes from removal is critical and cannot be undone once it is done. There are some other purposes to reasonable efforts that we'll talk about a little bit later. One is to try to reunify families if they are removed so that they can be safely returned home. And then the final purpose is to advance an alternative permanency plan so that children who can't be reunified with their family can find a safe, stable, and legally permanent placement. So those are a lot of reasons why reasonable efforts matter. And I want to talk now a little bit about the federal law and the background regarding reasonable efforts. And the federal law regarding reasonable efforts starts with the Adoption Assistance and Child Welfare Act of 1980. And this was a federal Title IV-E program that requires states to make certain reasonable efforts findings in child's welfare cases as a prerequisite to receiving federal funding for the child's stay in foster care. If the required findings are not made, or if the court finds that the agency did not make reasonable efforts, then the agency is denied foster care reimbursement for the time during which the judge determines that no reasonable efforts were made. And there's sort of different kinds of reasonable efforts and different consequences depending on which type of reasonable efforts that we're referring to. And I'll get to that in just a little bit. So one of the first categories of reasonable efforts under this federal law is reasonable efforts to prevent removal. So the Child Welfare Agency has to make reasonable efforts to maintain the family unit and prevent unnecessary removal. Now, the timing where this finding has to be made is within 60 days of the child's removal. But I want to pause there and explain because that can be a little bit confusing. It does not mean the department has 60 days to make reasonable efforts after a child has removed. When we're talking about reasonable efforts to prevent removal, it's sort of a bright line where you're only looking retrospectively after removal occurred. So they don't have 60 days to sort of cure or fix the reasonable efforts finding regarding the effort to prevent removal. We're solely looking at what they did before removal. However, the court has 60 days to determine whether or not that effort was reasonable. So it's that 60 days is the allowance for the court to make the decision, not for the department to make reasonable efforts after removal. Also, the consequence if the court does not make this finding or finds that the agency didn't make reasonable efforts is that the agency will not receive Title IV-E dollars for the duration of the child's stay in foster care. Now, I think a couple of things that are important to notice about this. One is that that's a pretty significant consequence for the lack of reasonable efforts. And the reason, again, is because I think the federal government wanted to emphasize that removal is itself very consequential. It's a bell that can't be unrung. And once that child is removed from the home, the damage to the child and the family can't be erased. So they wanted to emphasize to the agency that there would be a pretty substantial consequence if reasonable efforts are not made. And the thing I want to emphasize about that is also that denial of funds does not affect funding for the child's placement. So it's the agency that doesn't receive federal reimbursement for the cost of the child's care. It is not that the child's placement does not receive funding. So it isn't that the child's foster placement does not receive funding. It simply means when the state agency seeks federal reimbursement for the cost of that funding, they will not get that federal reimbursement. So I want to try to make sure that we clarify exactly how that funding denial works. It's also important to notice that federal law does not require reasonable efforts to be a prong for removal findings. And we'll talk about this a little bit more when we talk about Texas law. So the federal law requires that the court has to find continuation of the child's in the residence would be contrary to the child's welfare, or that placement outside of the home is in the child's best interest. But importantly, under the federal framework, a judicial finding that the agency failed to make reasonable efforts does not prevent a finding that the child needs to be removed from the home. So those two findings are both required under the federal law, but they're not linked, they're independent. So you can find one and not the other. And as we'll see later on, that's different than the way that Texas has structured a lot of its reasonable efforts findings. So now I want to move on to reasonable efforts to finalize permanency. And in this type of reasonable efforts, the child welfare has to make reasonable efforts to reunify the family, or if the family can't be reunified, to finalize an alternate permanency plan. And that can be adoption, legal guardianship, relative placement, APLA, or it's often referred to as aging out of care. Importantly, the timing is also different. This finding has to be made within 12 months of foster care entry and at least once every 12 months thereafter. Also, the consequence, the impact is substantially different, because if the court does not make this finding, the agency will not receive Title IV-E funding for the child's placement until such a determination is made. So unlike the previous reasonable efforts finding where that is not made, it's a denial for the child's entire stay of care, this simply puts a pause on the reimbursement funding that can later be resumed if the reasonable efforts are made and the court finds the department is in fact making reasonable efforts. So that's a very important distinction here as well, is that it's a pause rather than a bright line denial of all funding for the case. So the federal law also has judicial responsibility to document reasonable efforts in the court order. So it's not simply that the agency has to make these reasonable efforts. There has to be explicit documentation by the court when they are reviewing the case. And it has to be done on a case-by-case basis, and it has to be stated in the court order. So if reasonable efforts are not documented in the court order, a transcript is the only other documentation that will be accepted to verify that those reasonable efforts findings were made. That means that the affidavit of removal is not sufficient, nor is a nunc-pro-tunc order to correct a deficient order that was authorized in the first place. Also importantly, court orders that only reference state law and don't meet the federal requirements for reasonable efforts are also not acceptable. So it's important both that the agency make these efforts and that the court thoroughly document those efforts. And we will see in a little bit later, there have been some efforts by the Texas legislature to make that documentation even more explicit. So when we talk about sort of the federal legislative intent, I think if you look at sort of the Senate report regarding the federal legislation, they also emphasize that in addition to some of the other purposes that we've talked about, that reasonable efforts were supposed to be a safeguard against inappropriate agency action. So they were supposed to prevent the agency from making a knee-jerk decision regarding removal and really make that to be a sober and family-specific decision that's focused on the safety of the child. And they really didn't want these reasonable efforts requirements to merely become just a pro forma exercise in paper shuffling or box checking just to ensure that states obtained federal funding. But they understood that there was a risk that they would become precisely that. So there was a risk that these would be, instead of being very specific, instead of being very fact intensive, would just become a box that's always checked to make sure that state funding is matched with federal funding. They tried to make sure that the policy was not overly prescriptive. So they didn't want to get into detail, but with exactly what they meant by reasonable efforts or the specific actions they were looking for to determine whether or not those efforts were reasonable. Again, because they wanted to make sure that these decisions were made on a case-by-case basis. They were specific to the child and they were specific to the family. So when we look at the federal structure, we can see that when we're talking about federally required findings, there's sort of a branch for family preservation and a branch for alternative permanency. So for family preservation, there are reasonable efforts that need to be made to prevent removal. And then if that child is removed, there have to be reasonable efforts made to return the child. If family reunification is not possible and you're looking at an alternative placement, then you're looking at reasonable efforts to arrange and stabilize a permanent placement for the child. And when we talk about the federal definition of reasonable efforts, they're very specifically not defining reasonable efforts. And they explained in some of the legislative intent that to do so would be in direct contradiction to the intent of the law. And again, because they want these decisions to be made on a case-by-case basis specific to children and their families. However, there is some guidance that the federal policy does offer. First is regarding the health or safety of the child. So one thing to think about when we're thinking about reasonable efforts is, would the child's health or safety been compromised had the agency attempted to maintain them in the home? The next three are regarding services that the agency could have provided to ameliorate the danger in the home. And those services could have been to address factors present in either the child or the parent. So in other words, did the child have some physical, emotional, or psychological condition that made them challenging to safely parent? Did the parent have physical, emotional, or psychological conditions that made it challenging for them to be a safe parent? And what services did the department or agency provide to try to address those factors in either the child or the parent? Were the services customized? Were they truly individualized to the needs of the family, or were they just a standard cookie cutter packages of services that everyone gets? Were the services genuinely available? Did limitations exist regarding the services availability, including transportation, language, or other accessibility barriers? And if those barriers existed, what efforts did the agency undertake to overcome those obstacles? And then the final one is, what are the agency's activities that are associated with the permanency goal? In other words, if the permanency goal is reunification, has the department started to increase visits or planned a scheduled return home? If the goal is adoption, has the case been set for trial? If it has been set for trial and their parents' rights have been terminated, is there a child in an adoptive home? If they're not in an adoptive home, have they been placed on state and national adoption exchanges? What are the specific efforts that the department has done to advance that permanency goal? So now I want to talk about Texas law. Now that we sort of know the federal framework, I think it's important to understand how that meshes with some of the reasonable efforts law in Texas. And in the first place that reasonable efforts is mentioned under the Family Code is in 262.001, and it provides the general context for reasonable efforts. And the guidance it provides is that in determining reasonable efforts that are required to be made in respect to preventing or eliminating the need to remove the child from the home or to make it possible to return the child home, the child's health and safety is the paramount concern. So oftentimes it's said that sort of reasonable modifies efforts, and we think about what is reasonable, that reasonableness is related primarily to the child's health and safety. So that's sort of the lens through which all reasonable efforts are viewed when we're talking about making findings regarding them under the Family Code. And the next place we see reasonable efforts is at the ex parte emergency removal hearing. So reasonable efforts consistent with the circumstances and providing for the safety of the child were made to prevent or eliminate the need for removal of the child. That finding has to be in the ex parte orders prior to a court order, an ex parte hearing after a court order. It has to be both in the affidavit and the court order. Also, I think it's important to note, to go back to that difference between state and federal law. Under Texas law, that reasonable efforts is part of a four-pronged requirement to affirm removal. So when we talk about federal law, you could make a denial of reasonable efforts, but still have authority to remove the child. That's not so under the Texas framework because it's a four-pronged test where all four prongs have to be met. So there has to be an immediate danger to the child, there has to be continuation in the home would be contrary to the child's welfare, there has to be no time for a full adversary hearing, and there has to be reasonable efforts. If any of those are not present, then the court can't affirm the removal. So that's a difference between how the federal law is structured and how Texas law is structured regarding reasonable efforts. Also important to note, under House Bill 968 and House Bill 1087 in this legislative session, they added requirements regarding specific documentation of reasonable efforts. So now in all of these emergency removal orders and the affidavits, they have to describe with specificity and in a separate section of the order all the reasonable efforts that were made to prevent or eliminate the need to remove the child or to return the child home. Also, while it's not mentioned explicitly under reasonable efforts, House Bill 968 requires the department to do some specific actions to prevent removal, and those actions are to explain why a kick-out order of the perpetrator would not have kept the child safe in the home, and why a parent-child safety plan would not have kept the child safe in the home. So while those aren't listed as reasonable efforts, they are now specific actions that are required by the agency and the court to affirm removal. And I think it's interesting is that's getting into that sort of minute level of detail about what is reasonable that the federal framework has tried to sort of stay away from listing specific activities. So there are now some specific things that have to be done under the family code for the department to avoid making sure that those efforts were there to try to prevent removal from being necessary. So moving on to the adversary hearing, and here I think it gets very interesting because even this early in the case, we already see sort of two types of reasonable efforts. So at the adversary hearing, the court has to make both reasonable efforts findings. They have to make findings regarding whether or not the department made reasonable efforts to prevent or eliminate the need for removal, but they also have to make findings whether or not the reasonable efforts have been made to return the child home. So already at this stage in the case, you're already having to make reasonable efforts findings on both levels. Now, again, one of the things that's important to note is the way the Texas Code is structured is these are all part of a three-pronged test. So if these reasonable efforts are not made, the court has to deny removal and has to return the child home. That's the language of the adversary hearing. So again, we see a difference between the Texas structure and the federal structure that sort of links as part of a pronged test reasonable efforts to some of the endangerment findings. Also, Texas has some additional reasonable efforts that don't have a federal corollary. For example, in 262-201G, the court has to find for a parent who was not involved in the circumstances for removal, whether or not reasonable efforts have been made to enable that person's possession, but possession by that parent presents a continuing danger to the physical health and safety of the child. That level of specificity in the court order that we saw in the adversary hearing, that we saw in the ex parte hearings, was also added to the adversary hearing order by House Bill 1087. So that order now has to describe in a separate section and with specificity all the reasonable efforts that were made to prevent or eliminate the need for removal of the child at home or to place that child with a non-custodial parent. So they have to be thoroughly documented now in every court order. So the next place we see reasonable efforts is at the status hearing, and we probably don't think about reasonable efforts finding as much at the status hearing because we don't think of the child quite going home or having a permanency plan finalized at that stage. But the status hearing really sets what reasonable efforts are because it defines what the service plan is, and that service plan and whether or not it's followed and whether or not it has everything that it needs to have in it is a big part of what the reasonable efforts findings will be in the future. So even though the status hearing the focus is not on returning the child home, it really sets the stage for all the reasonable efforts findings that will subsequently take place. So moving on to permanency hearings before and after a final order. So here again, we see that now the court has to determine the appropriateness of the primary and alternative permanency goals for the child and has to rule whether or not the department has made reasonable efforts to finalize that permanency plan, including concurrent permanency goals. I want to pause here because I think there's some new importance about these findings I'm going to discuss a little bit when we get to the next section regarding the changes that were made to the termination grounds. But I also want to focus a little bit that this applies not just to permanency hearings before a final order, but also applies to permanency hearings after a final order. So this applies to children who are in the permanent managing conservatorship of the department. And I want to emphasize that because I think in those cases specifically, oftentimes it's hard to generate the sense of urgency or accountability that we see in TMC cases because there's not that threat of trial or termination on the cards. But the department's obligation to make reasonable efforts don't end for a child in PMC. And so that finding is still critical for the department at that stage of the case. And I think it's perfectly acceptable for practitioners to really make sure that that finding is there and to dispute that finding if it's not, because again, as we see, that would put a pause on funding for that child, but it wouldn't, that can be cured at a later date. So if the court finds that for a child in PMC, the department isn't making reasonable efforts, that puts a pause on the department's reimbursement that can be cured if they come back and can demonstrate that they are in fact trying to make reasonable efforts to establish a permanency plan for the child in PMC. So the major change that was made regarding reasonable efforts was made by House Bill 1087. And what it did is it added a reasonable efforts prong to the termination ground under 161.001. For the longest time, it has been a two-pronged test for termination. The court has to make findings that clear and convincing evidence was there to ensure that termination is in the child's best interest, and that the parent committed one of the acts justifying termination that we sometimes refer to as the alphabet ground. But now the court cannot order termination of parental rights in a suit filed by DFPS unless they find by clear and convincing evidence that DFPS has made reasonable efforts to return the child to the parent before commencing trial on the merits, and that despite those reasonable efforts, a continuing danger remains in the home that prevents the child from being returned. Now, interestingly, the court does not have to make this finding at the termination stage that reasonable efforts have been made if a service plan for the parent was waived due to aggravated circumstances. And we'll talk about aggravated circumstances more in just a little bit, but I think that's an important thing to realize about this new prong is that an aggravated circumstances finding sort of alleviates the need to make this finding. I also think it's important to note that the court has to include a separate section in its order, even at this late stage, with specificity, all the reasonable efforts that were made to return the child to the home. And so I think that's a fairly significant change. And one of the things I wanted to go back very quickly to talk about is how this might impact reasonable efforts findings at the permanency hearing stage. So those discussions about whether or not the department has made reasonable efforts and whether or not the court makes those reasonable efforts findings, I think take on new significance in light of this new prong to the termination ground. But I do want to emphasize that when we're talking about findings at the permanency hearing stage, those findings can be cured. So in other words, if the court finds the department has not made reasonable efforts, they can put a pause on funding, but they can come back and review that at a later date to see if the department has corrected the situation and has now made reasonable efforts to that parent. So the stakes are higher, but I also want to emphasize that those findings at a permanency hearing are not set in stone. They can be corrected at a later date. And while there's no change to the ICWA statute regarding this, I wanted to talk a little bit about it because I wanted to put it in context. So if a child is subject to the ICWA regulations, since they've been around, it has always required for termination of a parent's rights, has required proof beyond a reasonable doubt that active efforts were made to provide remedial and rehabilitative services to prevent the breakup of the Indian family, but they proved unsuccessful. So you can see that's sort of similar to the new reasonable efforts ground that we have added in Texas under 161.001. In fact, the ground that we've added in Texas is not as high a level of requirement as the ICWA ground, because ICWA requires beyond a reasonable doubt as a level of proof and active efforts instead of reasonable efforts. So it's similar in that it has this prong for termination, but ICWA is still even a higher standard even than the new law that was passed in Texas. So there were some termination grounds that did specifically mention reasonable efforts, and one of them was constructive abandonment. So this is 161.001B1N, and this applies when a child has been in the permanent or temporary managing conservatorship of DFPS for not less than 6 months. The department made reasonable efforts to return the child to the parent. The parent has not regularly visited or maintained significant contact, and the parent has demonstrated an inability to provide the child with a safe environment. Now, I think what's interesting about that is this was sort of unique as a ground because it did in fact explicitly mention reasonable efforts, but now reasonable efforts are required for every single termination finding. So in effect, this may sort of be subsumed because this is no longer unique in its requirement that reasonable efforts would be made. So another termination ground I think that is relevant to the reasonable efforts discussion is ground O, that requires the parent to comply with the orders of the service plan. Now, there has been a defense added to ground O that was required for the parent to prove by a preponderance of the evidence that if they were unable to comply with the specific provisions of the court order and they made a good faith effort to comply, and that failure to comply was not attributable to any fault of the parent, then the department couldn't proceed on ground O. Now, I think what's interesting about that is that was sort of very similar, I think, to some of the facts that we talk about when we talk about reasonable efforts. But now that we have this new prong in the termination ground, I wonder how much this might be used by lawyers, because as you can see, the burden here under this provision is on the parent. they have to be the movement here, and they have to prove this particular defense by a preponderance of the evidence. But under the new reasonable efforts prong, the burden is on the department, and they have to prove by clear and convincing evidence that they did in fact make reasonable efforts. So I'm curious to see if some of the relation and the factual arguments regarding this ground might just be subsumed by arguments under the new reasonable efforts prong. The termination ground of inability to care has long required reasonable efforts. This was a ground that is available if the parent did not commit one of the acts under 161.001, but they had a mental or emotional or mental deficiency that rendered them unable to care for the child, and that deficiency would last until the child's 18th birthday. And so that has always been an option for termination for parents who have these particular issues, and has always required reasonable efforts to return the child home. But now, as we can see, that's something that doesn't make it as different as it used to be in relation to termination grounds. Now that reasonable efforts will apply to every case under 161.001. And lastly, I think it's important to note that reasonable efforts continue to apply even if a child chooses to enter extended jurisdiction after they become 18. So even at that stage, if the child chooses to remain in care, the court still has to make findings whether the department is making reasonable efforts to place that young adult in the least restrictive environment necessary to meet their needs, and whether they're making reasonable efforts to finalize the permanency plan in effect for that young adult, including permanency plan for independent living. And again, these are that findings regarding finalizing the permanency plan, which, if they are not made, put a pause on funding, but don't end funding entirely. So I want to talk just a little bit about some of the exceptions to reasonable efforts. And some of those exceptions are, first of all, regarding aggravated circumstances. The statute that we mentioned earlier, Family Code 262-2015. And aggravated circumstances apply when the parent has abandoned the child, if the child is a victim of serious bodily injury or sexual abuse, if the parent committed a violent offense against the child or another child of the parent, if the parent committed murder or manslaughter of the child's other parent, or for registered sex offenders. Now, the consequence of making a finding under aggravated circumstance is that it waives the requirement for a service plan, it waives the requirements for reasonable efforts to be made to return the child to the parent, it accelerates the permanency hearing schedule so that it can be made within 30 days of the finding, and also accelerates the trial schedule. And finally, reasonable efforts made to finalize the permanency plan for the child still have to be made. And as we've seen, it also waives the requirement for the court to have that reasonable efforts to return the child finding to be made at the termination stage of the case. So that's a new significant development that I think will impact how many cases are filed under the aggravated circumstances statute. And there is no mention of reasonable efforts in the court-ordered services statute under 264-203 that received substantial revision in the 87th legislative session, but it makes no mention of reasonable efforts. And if you think about it, it makes sense because under that ground, the idea is that the child has not been removed from the parents, that the parents are working services, but the child is still in the home. And because of that, there's no requirement for reasonable efforts to either prevent removal or return the child, because the idea is that the child is still with the parents. I believe that's all we have for the black letter law. So I will stop sharing my screen and I will turn it over to Judge McCraw to begin our simulated and fictional fact pattern regarding a hearing regarding a reasonable efforts finding.
Thank you, Dylan. All right, so at this point, we're going to move into the simulated fact pattern as Dylan just explained. At this point, we're moving forward in that testimony and evidence have already been presented to the court. And so at this point, what we're going to do is kind of move into closing arguments for this portion of the exercise. And we have got, just to kind of give you an idea of who the players are for this portion, Ms. De La Cruz is going to be the attorney for respondent mother, and that will be Ms. Williams. And then we have Mr. Moench, who will be serving as the attorney for respondent father, which is Mr. Hernandez. And then we will have Ms. Corbin serving as the attorney for the department for CPS. And so that's kind of the roles each of the attorneys will be playing. All right, so let me ask, are each of the attorneys ready to proceed at this time?
Yes, Your Honor.
Yes, Your Honor.
All right. All right, so the court has already received the testimony and evidence presented at this time. I'd like to go ahead and moving into closing remarks. Ms. De La Cruz, my understanding is you are the one who is the movant in this hearing. You are the one that filed the motion for lack of reasonable effort. So I'm going to go ahead and turn it over to you for closing remarks at this time.
Thank you, Your Honor. On behalf of my client, Ms. Williams, I am asking the court to make a no reasonable efforts finding with regard to the department's efforts to finalize proposed permanency plan for the family pursuant to Texas Family Code 263.306. At this time, the department's primary permanency goal is family reunification. However, based on the testimony presented today, it is clear the department has not made reasonable efforts to attain the goal of family reunification. Ms. Williams' court-ordered service plan includes that she must complete an alcohol and drug assessment, follow all recommendations, engage in and complete individual and family therapy along with parenting classes, complete a domestic violence assessment, and complete random drug testing. My client has completed an OSAR assessment, and it was recommended that she complete a 90-day inpatient drug treatment program and follow all aftercare recommendations. Ms. Williams has been informed by the department that she must go through her Medicaid provider to pay for and enroll for this inpatient program. Upon discussing with Medicaid this issue, she was told that they would only cover a 30-day stay, at which time she will be discharged. The department has presented today that they are not willing to accept this 30-day inpatient stay as the OSAR recommendation is for 90 days. However, they insist that my client must go through her own insurance to pay for this service. Additionally, you heard testimony from the caseworker today that she's provided a list of inpatient drug treatment facilities to my client and told her to figure out which ones had an available bed. After spending several days and many hours reaching out to facilities, Ms. Williams has discovered that the closest facility with an open bed at this time is over 4 hours away. Her children are both under the age of 6, and she's never spent more than a few hours away from her children a day prior to this removal. The court has ordered weekly visitation for 2 hours each visit, and Ms. Williams is concerned that if she were to attend inpatient treatment at this facility, it would severely impact the visitation due to the age of the children and the distance from the children's current placement. She has located an intensive outpatient treatment program within this community, and she will begin immediately in the interim. However, the department has stated that they are unwilling to accept this alternative to inpatient treatment. We would like to emphasize that this is not something we're asking at this time to be done in lieu of inpatient treatment, but merely want to do this as something that is a stopgap in between. She wants to engage in this service and be immediate, since it is immediately available to her while she's waiting for a bed in a facility that's closer to home. Caseworker has also testified that she has referred Ms. Williams to NA and AA classes, but that she's unable to verify whether or not she's actually attended any sessions. This referral to NAAA is not a part of Ms. Williams' court-ordered service plan, and it should not be used against her. What I think that this court should focus on is the fact that my client has complied with multiple requests for random drug testing, and that all of those results have come back negative for all illegal substances. In addition, she's taken initiative on her own to locate community resources to address the concerns related to the drug use at issue. The department has also raised concerns with the fact that while my client has begun attending her individual and family parenting classes, she's only attended about half of her appointments. Ms. Williams has made it very clear to the caseworker that she does not have a reliable means of transportation at this time. While she and Mr. Hernandez were living together, they had one vehicle, and he's the one that transported her and the children to all of their appointments. Since there's currently a protective order in place and the vehicle does belong to Mr. Hernandez, she's having to rely on rides from individuals and assistance with bus fare. She's discussed this with the caseworker, and yet the department has not provided opportunity to give her rides. They have not offered to give her bus fare. And in addition, they have not tried to locate or identify providers for her that would have the option of virtual sessions. Finally, as it pertains to reasonable efforts to reunify the family, the last 2 parent-child visits for my client have been canceled due to scheduling issues with the foster parents. These visits have not yet been rescheduled, and it's going on 2 weeks since my client has last seen her children. What we heard today is that the department is unwilling to compromise and is slow to assist my client, which does not make for reasonable efforts to reunify. For all of these reasons, we're asking that the court make a no reasonable efforts finding and that they order the department to remedy these issues in a timely manner. Thank you.
Thank you. And Ms. De La Cruz, just a couple of questions for you. With regards to the 90-day treatment, my understanding is Medicaid will only cover 30 days. Is that correct?
That is correct, Your Honor.
And in that list of possible treatment options for inpatient treatment, do you know if any of those options provided by CPS are to be covered for the 90 days if Medicaid was only willing to pay for that first 30?
Your Honor, it has been the position of the department that since my client has Medicaid, that she must go through her Medicaid provider to pay for that. So Medicaid has said that they will not provide a waiver and will only cover the 30 days.
With regards to transportation, I know you indicated that she has not been offered any bus passes or any possible ride options, things of that nature. Do you know if she has reached out to indicate that she needs assistance with transportation or requested any type of bus passes?
My client has represented to me that she spoke to the caseworker at least a week ago and had brought this to her attention when asked about why she was missing half of her appointments.
Okay, to your knowledge, it was first raised about a week ago?
Yes, Your Honor.
Okay, and my understanding on the therapy and the parenting classes, are those being requested to be done in person at this time, or do you know if there have been online options available?
So, Your Honor, my client has attended about half in person. She would like an option for virtual since she does not have reliable transportation. It is not something that she's been able to verify that the current provider has as an option to her.
Thank you. I'm going to go ahead and ask if we can turn it over to Mr. Moench, if you'd like to go ahead and proceed with closing remarks regarding your client.
Yes, thank you, Your Honor. Regarding Mr. Hernandez, we also are requesting a finding that the department has not made reasonable efforts to finalize the permanency plan. Mr. Hernandez is Spanish speaking only, and he is willing and happy to participate in the services, but the department has not identified Spanish speaking service providers for his parenting classes or his individual therapy. And until that's done, he can't comply with the court orders. And so he's willing to engage in those services, but without services that can be provided in his primary language, then he is not able to make progress, Your Honor. So we are asking that the department be found to have not made reasonable efforts in his case. Regarding the drug testing, Your Honor, I think this is a classic example of the department simply settling for a one-size-fits-all plan rather than making it specific to Mr. Hernandez. He has never had a drug problem, Your Honor. His drug use was not the reason why this case came to be. He's never tested positive for drugs. He's never been arrested for drugs. He's worked at the same job for the last 4 years, including 3 years prior to this case even coming to be. And he is screened regularly for drugs at his work, and he's never turned up positive. He signed a release of information to the department so they can have access to all of this information, yet they continue to request drug tests from him despite it not being relevant to any of the safety concerns regarding Mr. Hernandez and these children. So we are asking for that requirement to be waived, and we were asking for the department to make a finding that no reasonable efforts have been made regarding Mr. Hernandez.
And Mr. Moench, similar questions to what I asked of Ms. De La Cruz. With regards to your client, do you know if any options were made available to him for the domestic violence class or the parenting classes with them being online with a Spanish-speaking option?
No, Your Honor, and he does have a reliable internet connection. That is something he is willing and able to do.
All right, and regarding those classes, is the department fully aware that he is Spanish speaking only, or has a specific request been made to them that he needs Spanish speaking options?
Your Honor, the department has been aware that Mr. Hernandez is Spanish speaking only since the very inception of this case. And I've tried working with the caseworker to try to identify placements, and they simply have not been able to provide them to us.
Thank you. And Ms. Corbin, I'd like to go ahead and turn it over to you if you'd like to proceed with closing arguments for the department.
Yes, thank you, Your Honor. The department believes that they have made reasonable efforts towards the goal of family reunification. You heard testimony today that mom does have a bed. It may be 4 hours away, but the OSAR recommended inpatient treatment. And so the department has set up these necessary referrals. She did attend the OSAR, and then they recommended 90 days inpatient. We do ask that she utilize her resources, as she has Medicaid and other resources. And so because that evaluation was set for 90 days, we do believe, given her significant drug history, that that is in the best interest for her sobriety and future stability. As far as transportation issues, you did hear testimony that only 1 week ago we were notified of these transportation issues. The department is very short on resources. And so you heard testimony that the worker has put her on a list for a bus pass. Unfortunately, the list is long and there's many people who need these resources. So the department is making efforts, and her name was put on the list, and referrals were sent to her to utilize community resources to see what's out there. As far as the visitation, we do recognize that the children and their mother have missed 2 visits, and the department is working to kind of, make up that time. We also recognize that if Ms. Williams does go to that inpatient treatment that's 4 hours away, it's probably not in the best interest of the children to travel 4 hours there, 4 hours back. And so we don't want to set up another visitation that has to get canceled if she is able to go to that inpatient treatment. So the department does have some hesitancy on setting those up again. As far as father is concerned, his request for Spanish-speaking providers is similar. The department is very low on resources and contractors, so his name has been put on a waiting list, but we recognize time is of the essence with these cases. And so the referral has been put in, we've made recommendations, but it's a matter of what providers are available. And so the department is making attempts to get him a Spanish-speaking provider, but his name is on a list, and that's the best that they can do. Lastly, as far as the drug testing, we do recognize that Mr. Hernandez has signed a release of information, but the department's hands are tied because we cannot get those records. So if Mr. Hernandez is able to get those records and supply them to the department, they would be more than happy to receive them. But we would like him to recognize he was living with Ms. Williams, who is a heavy drug user. So, the department just has concerns about what he was around, what he saw, what he used, given her significant history. And so we do ask that he take our drug tests to shorten this duration and back and forth of we have a release and we can't get these records. And so we believe that the department has made efforts with referrals, with recommendations, by encouraging the, various things for you to make a finding of reasonable efforts. Thank you.
And a couple of questions for you, Ms. Corbin, with regards to the inpatient treatment option that was 4 hours away. It is your understanding that if Medicaid paid the first 30 days, would the department be able to find funding for that additional 60 days being requested?
I believe with the 4-hour treatment facility far away, the Medicaid may cover all 90 days. We have not been told that I believe the 30 days is just for the closer facility that's within the same city that we live, but I think that the 4-hour one will cover the entire 90 days.
Has the department contacted that facility to determine what their policies are regarding visitation?
We have not.
Right. And if visitation is permitted as part of the facility's policies and procedures, would the department be willing to provide options for visitation to occur with regards to transportation, meaning trying to get the kids either to the facility to visit with mom or being able to request a furlough of some sort to allow mom to go visit with the kids elsewhere?
I think the department could definitely look into that and make necessary arrangements.
Has the department explored any options for visitation via Zoom, FaceTime, or any other, electronic means?
We have not at this time because of Ms. Williams's adamant disagreement about traveling to the facility 4 hours away, but that is something that the department can look into.
And I understand the department learned last week that there were transportation issues. Is this something the department has access to for bus passes and things of that nature, or can they assist with rides?
So we've put her name on the list for a bus pass, but I believe arranging the caseworker could most likely talk to Ms. Williams about picking her up. And so that is something that they would be more than happy to look into. But at this point, they've only put the mom on a list for some bus passes, which could probably take a month or so.
And it's my understanding the department has been unable to locate a Spanish-speaking provider for the domestic violence class and parenting class for father. Is that correct?
Yes, Your Honor, that is correct.
And has there been any options explored for online options for those classes?
Typically with domestic violence, the department prefers an in-person type of class so that they can observe their body language and make a full report. But I believe the department could look into online classes and put his name on the list. There is very few because it is so specialized, but the department could look into something such as an online class.
And lastly, the release of information that Mr. Hernandez completed for drug testing through his employment, was the release of information something that was court ordered for him to provide?
No, he provided that voluntarily.
All right. At this time, based on the information received through testimony and evidence, as well as the closing remarks, I am going to hold off on making a reasonable efforts finding. I would like the department and both Mr. Moench and Ms. De La Cruz and Ms. Corbin to appear back in 14 days. Within 14 days, I would like confirmation of what options are available for the visitation with the 90-day inpatient treatment program, the one that is the 4-hour away option. I would also like to have specific information as to how visitation will occur, if it's going to occur through electronic means or if something can be done with the children, but I would like a specific plan in place regarding that visitation. Also within 14 days, I would like specific information being provided to Ms. De La Cruz and her client for transportation. Either bus passes need to be available by that time, or an exact ride schedule needs to be identified so that mother is able to do visitation prior to starting the inpatient treatment, as well as make it to domestic violence classes and parenting classes. Additionally, within 14 days, there will have to be a provider identified for father that is a Spanish-speaking option. If there is not one in person, the department must identify within 14 days an online option so that he can get registered and immediately start getting those services done. At this time, again, I am not making a reasonable efforts finding. I am holding off for 14 days so that when we come back, that information can be identified and provided to the court so that I can review and determine if a reasonable efforts finding can be made at that time. And if there's nothing further, we will stand in recess.
Thank you, Your Honor.
Thank you. All right, Mr. Moench, I'll turn it back over to you.
Thank you, Judge McCraw. So I hope you all enjoyed our virtual simulated fictional reasonable efforts hearing. Hopefully the goal is to understand how specific these reasonable efforts need to be and how individualized they need to be each family, and also sort of the comprehensive nature that they can be, that they encompass everything from the services to visitation to the plan to get the child home. All of those things come into play when we're talking about reasonable efforts. So we now have time to answer any questions that any of you may have regarding reasonable efforts generally, regarding the new legislative changes regarding reasonable efforts, and you can submit those questions to the Q&A function. And Renee, do we have any questions that have come in through the Q&A function yet?
Yes, Dylan, we do have one question. Is the question of reasonable efforts a fact issue that will be submitted to the jury if a jury trial is requested? If there are reasonable efforts, is there there is a continuing danger in the home that prevents return to a child? I think this is just a compound question. So first, is this a fact issue for the jury? And then if there are reasonable efforts, is it also a question as to whether or not there's continuing danger in the home that prevents the return to the child? And of those efforts, what are those efforts and dangers? So the questions looks like basically are all of these things that would be submitted as jury questions to the fact finder.
So I can't think of a reason why they wouldn't be jury questions submitted to the fact finder. We submit the question regarding best interest as a fact finder to the jury. We submit the specific termination grounds. So I can't think of a reason why these reasonable efforts findings would not also be submitted to the jury. I think the question makes a good point that it's not merely reasonable efforts, is that the finding has to be that reasonable efforts were made and that there's a continuing danger in the home. So both of those things are part of that finding. So it's not merely one, it's both in a conjunctive form. So I think that's important to think about when we think about this new reasonable efforts finding. And again, unlike that affirmative defense, this is a burden on the department. The department has the burden to prove this by clear and convincing evidence. It's not on the parent to show that no reasonable efforts were made. Do we have any other questions, Renee?
I'm going to give this a few more seconds to see if there's another one that comes through. How does the limitation on a PCSP that they just enacted interact with showing reasonable efforts in relation to the PCSP on the adversary order?
You know, I think that's a really interesting question. And we talked about this a little bit in our legislative update, because you had two bills regarding PCSPs that sort of came at it from different angles. You had House Bill 730, which put a lot of restrictions on the use of PCSPs. It limited the time that they can be used. It required parents to be informed they were voluntary and that they could consult with an attorney before entering one. And particularly the biggest one is that the expiration date is that they're supposed to last for 30 days, but they can last for no longer than 90 days unless the person has an attorney and with their attorney voluntarily agrees to extend a PCSP. So in one sense, you've seen this sort of limitation on the use of PCSPs. But on the other hand, from House Bill 968, we saw from the legislature a requirement essentially that PCSPs be explored, that the court has to make a finding that a PCSP would not have kept this child safe in the home, and the reason why it would not have. So you have sort of two directions going on simultaneously, I think, regarding PCSPs in the new legislature. One, making sure that its use is limited, that it's voluntary, and that the parent understands their rights, and that it's not either a permanent or semi-permanent scenario. But on the other hand, that it's being explored to make sure that the child does not have to be removed. And like I mentioned earlier, I think it is interesting that that is now, even though it's not listed as a reasonable effort, it is now a specific action that's required by the department and a specific finding the court has to make regarding a very, again, fact-specific effort that has to be made to prevent rule from being necessary.
Since there's not a specified list of reasonable efforts, what is a judge expected to write in their findings about reasonable efforts being made?
Judge McCraw, I might turn that one over to you.
I think that I'm not going into very detailed, I guess, information, but I would think there would need to be a finding that reasonable efforts were made for services to be completed, specifically like in this situation, the domestic violence class, as well as the parenting class, that there were reasonable efforts made to obtain inpatient treatment for mother. There were reasonable efforts made for visitation to be followed through and to occur, things of that nature. I think if you can just make the finding that efforts were made to comply with that specific service, again, I think we're still in the early stages of not knowing exactly how much detail they're asking for. But I think if you can specifically identify that reasonable efforts were made for the parents to be able to complete the services, for the visitation to occur, for for the efforts made to make sure that everybody's able to comply with what's being requested.
Got another question here.
I was just going to say also, I think Dylan indicated in his presentation, much of this is going to be case specific and fact by fact. So
thank you. We've got another question here. When might be the best time to address the reasonable efforts issue concerning a service plan? At the 60-day hearing or after?
Well, it's a little bit, I want to make sure I understand the question. I think it's slightly different in the sense that at the 60-day status hearing, you are really sort of setting the table of what reasonable efforts are going to be going forward. And so I think that's critical because it really sort of defines what reasonableness is going to be. So I think it's critical, but as whether or not the department has made those efforts, I think that's probably more germane at a permanency hearing or at another hearing. I don't think you necessarily have to wait for a permanency hearing, but I think that's when it really becomes germane, is has the department really made efforts to reunify the family or to finalize the permanency plan if the permanency plan is not reunification. So as far as which is the most critical, I would tend to lean towards, I think the status hearing is critically important because you are, especially from a parent's attorney perspective, is you're sort of the idea is that you're signing off to this plan. So you're sort of signing off to what is reasonable, and the court is being asked to review the plan and determine whether or not it's reasonable. So even though it's not the critical stage, I think it really sets the table for the rest of the case.
For reasonable efforts, does the department need to investigate the non-custodial parent, even if the non-custodial parent lives far away and has never been involved with the child since birth? Do you think that reasonable efforts means providing transportation to the court hearings? So I think this is asking within the context of the initial removal. They did mention, for example, does the department need to complete a home study on the non-custodial parent? And what if the parent lives out of state?
I can respond and say, I think, again, it's very fact specific. Is this parent, have they been identified? Are they a possible candidate? What information does the department know about them? Have they located them? Have they contacted the department and are willing to be a placement? I think it's critical to make sure that this is fact specific. I think that's, again, kind of going back to that federal framework. There was a real reluctance to list specific things that needed to be done because they wanted them to be individualized to the case and to the facts of that case. And so saying that in every case, this is what a reasonable effort is, I think that's getting away from what the intent is. The intent is to make sure you do an investigation into this case and this family. So, the answer, the frustrating answer, but I think the true one is it depends. It depends on the circumstances. It depends on that parent. It depends on what the information the department has. And I think that's what judges and lawyers need to drill down into, is what are the facts that are specific and germane to this case? What makes that either a reasonable thing to expect the department to do or not a reasonable thing to expect the department to do?
Do reasonable effort standards change at all when a parent has a mental health diagnosis? More specifically, if the parent regains stability after an episode by a contested setting, does the timing of the reasonable efforts matter?
I think what I will say is I think my initial reaction is I think it definitely affects what efforts are reasonable, because the reasonable, again, this is fact specific. So the department's efforts in regarding to a parent who may have a mental health deficiency are not going to be the same as what's reasonable for their efforts to assist a parent who does not have that deficiency. So I think in that sense, they clearly are different because they're tied to the individual circumstance, the individual person's needs. So I think, yes, they should be different because that person's needs are different, their abilities are different, their parenting abilities are different, and their parent deficiencies and strengths are going to be different. So I would say, yes, that's something that's definitely going to be different. And I think that also changes over time, because parents change over time. That's kind of one of the things we want to have happen in these cases. We want parents to change and grow, and people with, a mental health diagnosis or a mental health deficiency, they can also change and grow over the course of the case. And then what is reasonable in relation to that person changes as that person's needs and abilities change.
Do judges need to write in a reasonable effort section within the order, and can it be a checklist the judge can use on each case within the order?
Judge McCraw, I'll look to you.
I was going to say, I think there are some forms and things that can be put into orders, but I do think it needs to be somewhat specific. I think just putting in a blanket statement of the effort, the department has made reasonable efforts. I don't think that can be it. I think if there was a portion of the order that indicated reasonable efforts have been made by the department with lines where they can actually go in, the judges can go in and write in specifically what reasonable efforts have been made, I think that definitely could help, make things a little more efficient and time saving. But I don't think it can be just a blanket reasonable efforts were made for, respondent mother to complete services and, for respondent father, I think that's going to be too vague. I think you're going to have to be somewhat specific and include additional information.
We do have a couple of questions that we weren't able to get to, but we are at the 1 o'clock hour. So I do want to turn things back over to Dylan.
Yes, thank you, Renee. So I'm going to try to share my screen to give everyone the MCLE number.